Welcome back to Inside Politics. Our guest today, Dr. John Weil from MTSU. He's a constitutional scholar and also a political science professor there. We're talking about the recent term of the Supreme Court and all the controversy coming out of this Roe v. Wade latest decision. Dr. Weil, as I think you mentioned in the first block, the court did not rule that abortion was illegal under the federal Constitution because it was murder, as many of the strongest opponents of abortion say that it is. The court ruled because they say it's not there's no right to that in the Constitution itself. Is that what's called being the originalism theory that seems to be becoming more and more strong on the court?
It does. You know, originalism in this case is sort of combined with historical practice. And basically what the court said is, you know, at the time the 14th Amendment was adopted, which would provide equal protection, there were in fact existing laws in place prohibiting an abortion. So it seems unlikely that the purpose of that law, you know, was to deal with it in one way or the other.
Justice Clarence Thomas, in his opinion, which was a part of the 6-3 court majority, said the abortion ruling should be extended to also overrule the constitutionality of contraception, same-sex marriage, even mixed marriages, maybe even desegregation. Now, he's the only justice that said that, but is the genie out of the bottle? Is this where we're headed to next, both in the states and perhaps in the courts?
I don't think so, but I don't know. And let me clarify one thing. Interestingly, I don't think he mentioned interracial marriage, which he has benefited from. I mean, he is in fact, he's part of an interracial couple. But yeah, but what's interesting, if you compare, Justice Gorsuch wrote a concurring opinion, which is the same thing that Thomas did, and Gorsuch made it clear. He said, I don't think the Constitution either outlaws or it's neither pro-life nor pro-choice. It simply doesn't discuss the issue at all. So his vote would be very clearly that, you know, he's not going to get into this. But, you know, Alito is very clear that he does not think his opinion applies to same-sex marriage, consensual sex, and probably another area that's escaping me right now. But just because he doesn't anticipate that doesn't mean that it couldn't be later carried in that direction.
Now, in the political arena, there are a growing number of Democrats, including the House Black Caucus, that wants President Biden to declare a national public emergency in the way of the Supreme Court striking down Roe v. Wade. Can the president do that? And if he did it, what would happen?
It would not accomplish much, in my judgment. You'd still have state laws on the books. I wouldn't want to take a chance if I were in that circumstance that I would be protected by a presidential order as opposed to a state law. And in fact, you know, yesterday's decision on the EPA suggests that the court is going to clamp down. Well, that of course deals with administrative agencies, but I think the same would be true of presidential mandates that seem to have the force of law. I think the court would be very skeptical of it.
So you think at this point, it's pretty clear the EPA ruling yesterday is not just aimed at EPA, it's aimed at all federal agencies, but you think it may also be extended out to executive orders by the president?
Well, you know, one of the things that bothered me a lot during the Trump administration was the attempt to take a couple $2 billion that had been appropriated for one thing and appropriate it for a border wall after Congress had rejected that. And I think there is a case to be made for reeling in executive powers, just like there is for reeling in administrative agency powers.
There's also been pressure brought on the president to issue an executive order. We've been talking about those, that abortions could be conducted safely and legally on all federal properties. Now, we've talked about the Hyde Amendment. How is it possible he could issue that kind of an order and have the Hyde Amendment still on the books?
Well, of course, permitting them on base and paying for them could possibly be two different things.
But you're using a federal property
property
that's paid for by the taxpayers.
That would be a little more indirect. I think the answer is we just don't know for sure. The president's press secretary seemed to express some concern yesterday about, you know, federal bases being used sort of as abortion enclaves. On the other hand, there are some military officials saying that it might affect recruitment to the military because people don't necessarily have the choice of what state they live in. If you got assigned to a state that prohibited abortion procedures, and you knew that could happen, you might be less likely to enlist.
Isn't the president himself once again getting himself in quite a dilemma on this? I mean, he's Catholic. Are we going to see archbishops and bishops now saying they're not going to give him communion again? Because now it's not the law anymore that he's trying to uphold to support abortions. Abortions aren't allowed, but he'd be out there leading the charge to try to get Roe v. Wade reinstated.
He's not the only one. I noticed that Nancy Pelosi apparently received communion, or I guess the sacrament, at the Vatican a week or so ago, and could not even, was receiving opposition to receiving it in California. What his religious beliefs are would not necessarily define what his obligation is to uphold and defend the Constitution.
Dr. John Weil is our guest on Inside Politics. He's a political science professor and constitutional scholar at MTSU. About to continue our conversation with the professor after this break.